Your child's preferences may not come into play in your Texas custody or divorce case at all. In fact, if children are under 12 years old in Texas, a court doesn't even have to consider their wishes or opinions. The thing is, once children turn 12, there's this old, long-standing sort of urban legend that they get to pick which parent they want to live with. But that's not actually how it works. At 12 years old, on motion of a party, a must consider and visit with the children in a divorce or custody case. So at 12 years old, all that has to happen is a judge has to listen to the kiddo and hear them out. And then what happens is they give the weight and credence to what the kid is saying based on the judge's own assessment of this child's maturity and ability to understand the situation. So if you think about it, how much credence would you give the 12-year-old in your life? Like, do they have a hard time managing their business? Are they still pretty immature and young? Maybe not as much credence. If you are having a 12-year-old who completely understands things, super responsible, can stay home by themselves and, stuff like that, maybe you'd give them some more credence. But like under 12 years old, y'all, courts are not going to consider the child's preferences. Now, sort of a backdoor way this can happen, perhaps through the testimony of a therapist. If your kiddo is seeing a therapist, a court might consider what a kid feels based on what a therapist would explain. But like directly, kids don't get to have a say in what a court does with where they're going to be and with which parent for how long. We really go back to the Texas Family Code and then a judge's assessment of what's in the best interest of your child. Texas law considers the relationship between each parent and the child when deciding what's in the best interest of the child in a Texas custody or divorce case. And here's the thing, if there's a super close and tight-knit bond between one parent and the child, and not really with the other parent and the child, that's going to play out in behaviors and different evidence your lawyer would present at court. Maybe in the child's communication with their therapist or with the teacher. Maybe evidenced by the time on your calendar that you spend with the child, doing one-on-one things, coaching their softball team, how much you're able to speak about the child and the intricacies of their personality. Like, it's pretty hard, honestly, to fool a court into thinking that you have a close relationship with your child when you don't. I'm not saying you can't, but like, people just talk about somebody differently when they really know that person. It doesn't change whenever you get to court. So if both parents would keep the child safe, if both parents would make sure that the kid is thriving, then you're going to get a lot more particular as a judge trying to figure out which parent should be the primary parent. They may look to the closeness of the relationship between you and your child in making that determination. In Texas custody decisions, your mental, physical, and psychological health as a parent could come into play. Because remember, Texas courts are trying to make sure that children are safe and that they're thriving emotionally, mentally, physically. And if you yourself are not a safe person and not thriving emotionally, mentally, and physically, how could a court trust you to make sure that's happening for these little people in your lives? So it can come into play if you're dealing with some significant mental health issues, if you've had safety concerns, if you've had suicidal ideations. Those things may come into the consideration of a judge when deciding who children should be with primarily and how parenting time is handled. If you're in the middle of a Texas divorce or custody case and someone involved has a history of domestic violence or substance abuse, you're going to have to proceed with caution. Everybody, you as the person involved in the case, the judge, your lawyers. And I think that the way to think about this is how severe were the issues and how recent were the issues. And then the more severe and the more recent, the more it's going to come into play in your case. Let's say 10 years ago, you try to commit suicide. So like pretty severe, but kind of a long time ago. It may just be one factor. You're like, in your divorce, like, hey, judge, that was 10 years ago. And what they're going to look for is your subsequent measures to keep yourself and your children safe. So if I was your lawyer and something like that come up, what I would say is like, okay, judge, that was 10 years ago. And since then, Mr. Smith has been under the care of this psychiatrist, taking these medications, has this safety plan in place, goes to this therapist every other week. So I'm proving to the judge you've got some guardrails set up so that this child will be safe with you. Now, with substance abuse, that's a little harder. Like substance abuse, proving that can be pretty hard unless you've been like admitted into an inpatient rehab. I mean, like, okay, we went to inpatient rehab. It's pretty obvious there was a substance abuse issue. But let's just pretend though, either you admit you did it or they've proven it. Then it's going to be about like, how bad was it? Were the children involved and how long ago? So say it was a year ago and you were drunk and you got a DWI and the kids were in the car. Ooh, that's pretty sticky. But a year, again, your lawyer's going to try to show you enrolled in AA. Maybe you did some outpatient rehab and you've committed to being completely sober and you haven't had a drop to drink since that one night and you're real sorry. They may put in some other guardrails during the divorce, like Sober Link, or we have to go do some sort of testing or blow before you're able to be with the kids. But the way to think about it is Texas courts want both parents involved. And just because you made a mistake a few years ago, they're not necessarily going to hold that against you forever, especially if you're trying to get better. Just think about in terms of how bad was it and how recent was it, and then work with a lawyer to put together your strategy and the guardrails you need to put in place to convince a judge that those issues are mitigated. You don't have substance abuse issues anymore or domestic violence issues anymore, and they can trust you with your children.